If you're looking for information on how to begin your divorce process, everything from how long you have to live in the state to what documents you file and how do you get the ball moving, then you have found the right video. Well, hello and welcome to the Illinois Family Law Insider. My name is Jeff Hughes and I'm the CEO of Sterling Lawyers. We are a family law firm exclusively focused on family law, and I have with me my co-host today.
Hi, my name is Katie VanDeusen. I'm the managing partner at Sterling Hughes.
Now, Katie, frequently clients, potential clients will call into our office, and then one of the questions that we get, our team gets, is how do I go about filing for divorce? And assuming they don't obviously work with our team to do that, let's walk through the process for helping someone go get a divorce action started. So really, what's the first consideration for potential parties to consider when they're going to file?
Yeah, so the very first step would be determining whether or not they are within the jurisdiction. So typically that's decided or determined by their address. So assuming that they are within Cook County, for example, then they would end up filing a petition for dissolution of marriage within Cook County.
And from a standpoint of residency, there are some very specific residency requirements for Illinois broadly, and then for the county that you file in. And what would those be?
So typically, Illinois as a state is always going to require 90 days of residency prior to filing any type of divorce action within the state. And then each county does have some specific requirements, meaning if you are located within that particular county, it probably is best that you file within that particular county. So if you reside within, for example, DuPage County, that's where you should end up filing. Typically, you will not be able to file outside of the county in which you reside. There are some nuances with regard to if you work in a particular county, then you can possibly file there. But most of the time, you're going to file where you reside in that particular specific county.
Yeah, and I've never actually seen it, but I know that there's like a loophole in there too, that if you have children living in a county, you can file there. But I know that there's some other very specific things relative to that don't apply to hardly anyone.
Well, and the other thing too to consider is when it comes to children, I feel like there are always special rules that apply. And when it comes to kids associated with divorce cases, you always have to go based on home state. Home state of a child is based on where the child has been primarily residing for the past 6 months. So if someone were to move here and not, let's say, for example, they had a child and they haven't been residing within Illinois or a particular county for that period of time, then home state could be challenged potentially. So there are almost like two different sets of timing requirements when it comes to jurisdiction.
But from a standpoint of just giving clients some comfort, if they've lived in the county for 90 days, they're going to check all those boxes, right? And then to actually file, actually back up on the residency thing, I want to point out too that just because you have your driver's license, for example, in Illinois, but you may live in Wisconsin for whatever reason, you do that does not give you residency. It's actual sleeping your little sweet little head in the state for those 90 days prior, right? That's what residency means.
Yeah, correct. It is primarily where you are living, where you are sleeping, where you receive mail. That is kind of how they determine residency. And then just going back to, whether or not there's a child included in a case, instead of that 90 days, it really should be that 6-month time frame, just to clarify that, because I don't want to give anybody the wrong impression of only being 90 days if they have kids.
Okay, so let's say they've established that jurisdictional requirement and they're ready to file. So what would be some of the options for someone to go and get the process moving?
Yeah, so I think One step that I would just strongly encourage anyone to take is really checking the Illinois Supreme Court website. There are a list of court forms associated with divorce cases. I think that's a really great starting point for anybody that's considering that route. It's just going to give you a lot of information surrounding forms, what forms to fill out, and what steps to take, and also like what legal issues you may run into. Specifically with starting the case, you're going to want to prepare and file what's called a petition for dissolution of marriage, and then possibly a summons.
Okay. What's the difference between those two documents?
So, a petition for dissolution of marriage is really going to lay out the specifics of that particular, of those two particular parties. So, for example, it'll have their legal names, it'll have ages, their residence, date of marriage, whether or not they have children and their children's ages. And then a summons form is really meant to notify someone that there's been a pending case filed against them, and they have a specific deadline within which to respond or answer and
Mhm.
file their appearance.
Okay. So filing appearance is just letting the court know you got the docs and you're here, you're ready to respond and deal with it going forward. That's what that means, right?
Yep, you're ready and willing to participate, and you may not want to participate, but that you file the proper paperwork to participate.
And one more thing related to these initial documents, if there is a need for an immediate court intervention by way of what we call temporary orders, like who lives where and what the visitation schedule is, or with the children, the parenting time looks like, you can also file an order to show cause for a temporary order as well, right? Where you
Um,
request a hearing with the court.
So typically with divorce proceedings, you will have to effectuate service on someone first, absent an emergency motion or some type of emergency petition. I would say most of the time judges are hesitant to enter any type of orders until they know that they have personal jurisdiction over someone. So that service piece is critical and crucial when it comes to a divorce case.
All right, so we just got in talking about the jurisdictional stuff, and I'm going to move into now the service part of it. So, Katie, once these documents are filed with the court and
Yep.
the clerk stamps them and the filing fees have been paid, once all that has been accomplished, what would be the next step for someone to take to keep the ball moving?
Yeah, great question. So typically, you're going to have the summons and the petition personally served on the other party or the respondent. And that's typically done either through a special process server or done through the sheriff's office. So typically, the sheriff's office is going to be the default in most counties, but you can opt into a special process server, which would allow you to personally serve someone through almost like a third party and not necessarily a sheriff or a police
Okay.
officer.
So, this is a private individual, a private company that just serves people court papers, right?
Correct.
Okay. And so you can go to the sheriff's department and then you got to pay their fee. And it's usually, I'm going to guess it's like 50 to 75 bucks for them to then drive the documents over to wherever the other party's living or at or working at or something. That's one option. And a lot of people certainly do that. The other option is to go hire a private individual. And sometimes the speed can be a little faster with private individuals because that's what they focus on. Whereas sheriffs, if they're having a busy day chasing bad people, then right, they're not able to get to your service that particular day.
Yeah, correct. I mean, I would say the major differences are that a special process server, you're going to have some element of control over when and how the other party is served, versus a sheriff's office, they're going to attempt service whenever is convenient for them, clearly. So that may not always be the fastest, or it may not always be the most convenient when it comes to timing of service.
And yeah, you brought up a great point there. I didn't even consider to talk about here, but there's a lot of sensitivity around service, right? If you want to have a civil process that to work through and be somewhat collaborative, sending a sheriff to someone's place of business to serve them divorce papers is not a good look, right? That does kind of throw gas on the fire.
Absolutely. I would tell you, in terms of approach and how you strategically handle certain cases, whenever I think of service, whether it's through a special process server or a sheriff's office, I really do think of standard litigation based case files that are not necessarily collaborative or cooperative, let's say, where the parties are potentially working together. It really is kind of, in my opinion, like last resort versus trying to work something out prior together.
I had a client one time come in to see me, and she was livid. I mean, this you could tell this case was going to be at least an explosive start. And we were in the first consult, and I asked her how did she receive the documents, because that's always kind of a leading indicator for, at least it could be, for how well things are going to move forward. And she's like, "Yeah, you know what I found? I found all the divorce paperwork, and it was right up next to a brand new lease for her soon to be ex husband across town." So that was the way he told her that he was filing for. He got the paperwork, he left them out next to a brand new lease, probably with his girlfriend's name on it or something, so she would find it. What a passive aggressive move! Oh man, and you can imagine that case was a real doozy for about the first 6 months until it kind of simmered down a little bit. So don't do that. That's a big lesson.
It's
Don't
true.
do that.
It's so hard to tell people that, you can't ever backtrack, right? And so that's what makes this time frame, I think, really vital, to make sure that whatever potential client, or if it's a person who's considering, moving forward in this way, to really think through what is best in their particular situation and giving them those options on the front end to hopefully avoid maybe a situation like that where it's going to be just a long, hard fought road in terms of, litigation and in front of a judge, and costly, and just the damage that takes, or the toll that it takes on your family.
Yeah. So last thing I want to just bring up would be for those cases where you do want to do it collaboratively, you don't want to blow it up and turn into another war. You can do a service methodology where you give them the paperwork, they sign document saying they received them, and that also will count, right?
Absolutely. Typically, with a case where we're either considering a collaborative approach, under the collaborative method, would be, if we're considering a collaborative approach, then typically we would end up providing them with the paperwork, and they would end up either voluntarily signing an appearance, or a waiver of service is very typical in uncontested case files. So there is a difference, though, between an uncontested case and a collaborative case. So
Right.
just something to keep in mind.
And the reality is the majority of our cases, it's done collaboratively, where there's an exchange of documents. You're not bringing out sheriffs to houses and businesses and that sort of thing.
Yeah, I would say those are the types of cases that I try to encourage potential clients. Those are the options that I try to present to them. Clearly, it's, you can't always predict those things or control those things, but you always want to present all of the options to the potential client if you can, and let them make that choice.
Well, thank you, Katie. And just one last question to help our listeners kind of move forward. Once the documents have been served or received and acknowledged, what would be, and every case is different, I understand, but what would be generally the next step for the parties to take to keep things moving?
Yeah, so once someone receives that paperwork and is personally served, they have to file an appearance within 30 days, as well as a response to the underlying petition for dissolution of marriage. If they don't do that, then they are running the risk of being defaulted, which is always a
That
dangerous
doesn't sound
territory.
good. That sounds bad.
It's not good. Yeah, I don't think I would never advise someone to go that route with regard to these situations. So.
Yeah. I feel like I've been defaulted a few times in life on a couple of things.
Unfortunately,
Yeah.
sometimes it happens, but yeah, not in these situations,
No,
hopefully.
not really. Well, thank you. I hope this was helpful to you. And if you are looking for more answers to simple questions related to your divorce action, feel free to look around our channel here. We put up a lot of videos every week to help people navigate through our family court system here in Illinois.